All right, our next case today is MN as the appellant versus Agency for Persons with Disabilities. Again, counsel for appellant, you may reserve as much of your 20 minutes as you would like for rebuttal. I'll set it at 5 minutes if you want something other than that.
5 minutes is fine, thank you.
You got it. All right, you may proceed when you're ready, counsel.
Thank you. May it please the court, I am Marissa O'Connor, the attorney for MN. So this appeal, we've outlined several different errors that arose through the agency's actions and the final order, but really there's an overarching error that has arisen that caused the rest of them, and that is the agency's failure to follow their own rules. So, and to be more specific, Administrative Code Rule 65G 4.0215 specifically says that a person can be disenrolled for various reasons, one of which would be moving out of state, such as our client did, and when they return, they are to be put on a waiting list until services can be provided. And that is if they have been out for more than 365 days. The rule does not set any end time period. It just says if it's been more than that 365 days, then they must be put on the wait list and until their services are available.
What about the last sentence in that provision you're talking about? Does the eligibility have to be reestablished?
No, it needs to be a level of care as opposed to the eligibility. They need to be able to make sure that they can provide that level of care.
So ADP is not disputing whether your client has autism, correct? I think
correct.
That's pretty correct. Okay. They're disputing whether he has the severity, whether he meets these statutory factors. That's what you went to the hearing over. Is that generally correct?
Generally,
okay.
Yes.
Was there ever a time in your client's life when he actually was determined to meet those criteria?
Yes.
Okay, so would that have acted as an administrative finality, or should it have?
That is our contention, yes. He was...
Has there ever been, was there, I think it requires a substantial change in circumstances, correct, if there's not going to be the finality. Did the law ever change in regards to these factors, do you know?
Not to my knowledge.
From the time he was approved previously? Not
to my knowledge. He was only gone for 5 years.
Did his autism get better? Did something happen that made him would have made him worse at one point and made him better now?
No, sir. When he moved out of state, it was simply for personal reasons, for the family. It was not due to any medical issues. He was receiving services for autism in Pennsylvania. And then when he returned, he was having the same characteristics. And his mother testified to this several places in the testimony. She talked about how his characteristics and symptoms were the same, basically the same throughout that time.
Do you think leaving the state is for a length of time, is that a substantial change in circumstances?
The rule does not specify a change of circumstances for leaving the state. It just says they become disenrolled and that they can go back on services once they can be re-enrolled. And by moving back to the state, he can be re-enrolled. And the problem lies in that level of care determination, because instead of an eligibility determination...
In the rule, it says if waiver eligibility cannot be reestablished, or if the client who has chosen to disenroll has exceeded the time period. So that seems to be two independent reasons why someone would go onto a waiting list rather than be re-enrolled. But one of those criteria cannot be reestablished. Doesn't that indicate to us that there needs to be a reestablishment?
I would say there does not need to be a reestablishment.
Why?
Sorry. Because it was not for medical purposes. It was not because they could not meet the level of care at that time.
Are Are medical conditions static?
I'm sorry?
Do people's medical conditions not change over time?
They do change over time, but autism is not a condition that is going to get better, that a person can be cured of. And there's no dispute that he had autism. It was they needed to determine the level of care.
Does the severity of one's autism change over time? Does their ability to manage that autism within the world change over time?
There may be fluctuations. In his case, there was not. His problems were the same when he left as when he came back. So there was not an issue of the eligibility.
There may or there may not be, and that's fine. But for the purpose of the rule, you're saying that there doesn't have to be a reestablishment because people's conditions don't change. And I think you're also telling me that people's conditions can change over time. While they may still have the diagnosis of autism, the severity of that autism might change, their ability to manage that autism might change, and frankly, that translates into their need as compared to all of the other people who are on the waiting list.
And right, the need is where the level of care comes in. The level of care, the purpose of that as determination is to determine what the needs are and what they can provide, what services can be provided. So level of care determination is different than the eligibility determination. He had already been determined as eligible. He hadn't changed at all. He came back, he followed the rules. The rules specifically says that you have to let them know you're re-enrolling. He did that.
But again, it says if waiver eligibility cannot be reestablished. That seems to me to suggest that eligibility needs to be reestablished.
In this case, it would be his coming back would be establishing that eligibility. He's going back to that same eligibility determination that was previously made. Just like if somebody had that level of care determination made while they were on services or on a wait list, and the level of care could not be provided, the services could not be provided for that level of care, that person would be disenrolled. But if they were able to get to a point where they were back and needed the level of care that the agency could provide, then they have established that eligibility again. But it's all based on the level of care determination as opposed to an eligibility.
Again, the rule doesn't say if a level of care cannot be reestablished. It says if eligibility cannot be reestablished.
In looking at the rule as a whole, it would be, if you're looking at it as a whole, it's when they come back, when they get to that point where they can be re-enrolled, then that is the point where it has been reestablished, and then it's a matter of putting them on that wait list until those services can be provided. And their expert even goes on to say that. I mean, their expert says once the eligibility has been determined at pre-enrollment, then they do level of care assessments on a yearly basis, and to make sure that they can maintain the services and the needs of that client for the services. So in reading the statute as a whole, it's whenever they're able to get back to that point where they can and want to re-enroll, that is when that eligibility has been reestablished. Not that another eligibility determination has to be done. They are treating it as if a whole new application has to be completed and the eligibility. The rule also states that to be able to re-enroll, that the person needing the services lets the agency know that they need the services, that they have the intent to re-enroll, they've been on services before. So that is also part of the rule, and that is what MN did. When he came back to Florida, he called the agency and said, I've been on services before, I want to get back on services. And they didn't even look at the previous information. They didn't look to compare how he was previously to how he was now. It was treated as a brand-new application and looking at that point in time, as opposed to how he was before to now. So
The only reason the eligibility had been cut off, it's not that his condition got better, it's that he left the state, correct?
he was disenrolled because he left the state. And we did bring up these issues in a motion for summary judgment. The hearing officer would not entertain the motion for summary judgment. At the hearing officer did not acknowledge this code in the final order. It wasn't even mentioned. And there was no analysis as to this code by the hearing officer directly, even though it had been raised on multiple times. And this is a fundamental error for them, because the agency what they did was they were exercising its discretion inconsistently with its own rules. It was also interpreting the rule that compels a particular action, which would be that going on the wait list after 365 days. But they continue to assert that it is a brand new application. And so their policies and practices are not complying with the rule. They did not consider this rule at all. And they tried to put an end date on it, which there is no end date. It doesn't say if you come back 5 years later, it's too late. It says if it's been over 365 days, here's what you do. They did not do that. And MN did what he needed to get re-enrolled and with his application. And like you said, they don't dispute the severity, or they don't dispute that there's a diagnosis of autism. He had the same characteristics. They didn't look at the previous record to even tell that. And as I said before too, if they were to have done a new level of care for a client who had been on services and not just left the country, it's the same situation. They would have had to do a level of care. If the person couldn't stay on services because it was too high of a level of care, then they would be disenrolled as opposed to terminating eligibility. It's a disenrollment, and coming back and being able to get services later on a new level of care determination would be the same thing. They would have to bring them back and at least put them on a waiting list, at a minimum, to put them on a waiting list until services could be provided, till there's funds, till there's an opening. And that was the other part of this that we had brought up, was the crisis situation. It was...
So one of the reasons why, and this is different than your situation, I acknowledge, but I'm trying to see how this rule works. One of the reasons why you might be disenrolled is, let's see, the client no longer needs waiver services. So if after 365 days, the client then decided that they did need waiver services again, by your contention, they should be put back onto the waiting list. And then the last sentence is when the effective date for being put on that waiting list is. And the two examples are when eligibility is reestablished or when the client requests reenrollment. Now, you're suggesting in your situation that the effective date should be when your client requests reenrollment.
Yes.
In the scenario where they weren't eligible for Medicaid service, or where they weren't eligible for waiver services, would that be a situation where eligibility would have to be reestablished?
It's our contention that no, it would still be a level of care determination to see whether they could get back on services, to see if they're at that point. But in reading the rule as a whole, it does, I see your point as well, because yes, there's an or there. They don't have to make both.
So there are scenarios within this list that would require a reestablishment of eligibility. You're just contending that moving out of state and moving back into state is not one of them.
I do contend that that is not an issue where they would have to establish eligibility. We contend that this use of the word eligibility in this rule is misleading because they're looking to get re-enrolled, not to redetermine eligibility. They've already been determined eligible, and it's still that level of care. And the agency rules set out what these level of care assessments are to be and what can be provided and how they're supposed to do it and when they're supposed to do it. And it conflicts, if you read this rule as meaning an eligibility to determination, that's conflicting with the other rules that apply to the agency for level of care.
So you're aware you're into your
Yes,
rebuttal time.
if I may reserve the rest, if there are no more questions now. Thank you.
Good afternoon, Your Honors. My name is Francis Carbone. I'm the General Counsel appearing on behalf of the Agency for Persons with Disabilities. May it please the Court. This Court should affirm the lower tribunal's final order for the following three reasons. The first is that due to the dynamic nature of the developmental period and the requirements in statute and rule, APD must comprehensively review eligibility whenever a new application for services is received. The second is that Rule 65G 4.0215 only speaks to enrollment and not eligibility. It also has a special carve-out for a specific circumstance in the rule. And lastly, the burden was properly placed here on the appellant because administrative finality does not apply where there is a significant change in circumstances.
It's a significant change in circumstances here.
So the appellant moved out of state for 5 years. I think it was something over 2,000 days.
So time is the significant change in circumstance?
I think that creates a possible change in circumstance. Here, there was more than just time. There was the fact that in Pennsylvania, the appellant received different treatment modalities and services which may or may not have ameliorated the presentations that are required under APD's eligibility rule. And
So if he was once determined to have need of services, why is there a need to have another determination? Solely because he moved out of the state. Wouldn't the eligibility just be related to whether or not he was back in the state, the very reason that you terminated the services in the first place?
Yes, sir. The statutes do not draw a distinction of types of eligibility. In fact, in Section 393.065, subsection 1, it says that only clients who are domiciled in the state are eligible. It also says in subsection 9 in the 2021 version that the agency must remove those from the waiting list who are either not eligible or not domiciled. And Rule 65G 4.015 plainly states in order to be eligible, one must. And it has 3 boxes that you need to check off. One is being over the age of 3, the other is having a condition that's qualifying, and the third is being domiciled in the state. So it is those rules.
Has anything changed in the law as far as the factors when he was originally determined to need services to now?
No, Your Honor.
So nothing changed from when he originally got the services to now legally, is that correct?
The requirements, no.
Requirements?
And that dovetails into another point that the agency would like to make. Rule 65G 4.014 defines autism as being pervasive, which means that it has to be always present and without interruption. It also has to be of an extended duration, which means that the condition reasonably can be expected to continue indefinitely into the future. And it's those 2 elements that caused or raised the question about...
You admit that in your brief, though, correct?
I beg your pardon?
Your brief, don't you state that he has severe autism and it's going to go through into the future?
We admit that he has a diagnosis of autism. We do dispute that the conditions and the presentations were not necessarily severe enough in order to qualify for eligibility. And this was adopted into the final order in paragraphs 26 and 27, where the hearing officer virtually adopted the agency's expert's testimony, which starts around page 204 in the transcript, that the appellant's presentations were markedly different at that time. For instance, he makes eye contact, he stays on topic and makes appropriate comments, uses language for a variety of functions.
I'm not disagreeing with you anything that the hearing officer found in regards. I'm just wondering why he has to have this determination again. Is this done in every case with every individual?
In the developmental period where the requirements of the condition are pervasiveness and extended duration, yes, it is. And Your Honor raises an interesting hypothetical because of the way that the statute is written, where eligibility is a binary question, even if the agency did not have information that an individual left Florida, it would nevertheless still be obligated to check whether or not somebody lived in Florida whenever they were coming back to the waiver. It would be one thing if all of this occurred outside of the developmental period, and the manifestation of this under the rules was not changed. However, here, nearly 40% of the developmental period was spent outside of the state, and after he had been disenrolled and determined to be ineligible.
The determination of ineligibility was based simply on relocating?
No, Your Honor, it was both. It was considering both the condition as well as the domicile. And here...
When was he ineligible? At what point did he become ineligible?
He became ineligible when he moved out of state in 2015.
Okay, so to get back to Judge Boatwright's earlier question, the only substantial change in circumstances between, was it 5 or 7 years that he was gone, is that he came back and time had passed.
The agency disagrees in that it appears, and this was discussed extensively at the hearing, that those different treatment modalities seem to have an ameliorative effect on the presentation. And because the severity component is key here, the agency needed to re-review that. In most instances, this is a pretty simple review if you take one of the other developmental disability conditions. Here, it's more intense because of the specific...
So I'm looking at some of the other reasons for disenrollment. Let's look at the client no longer meets level of care for admission to an ICF-IID. Can I read from that there is some sort of regular monitoring of the condition of the folks who are receiving waiver benefits to make sure that they still are at a specific level of care?
Yes, Your Honor, that's exactly correct.
And that if you live out of state for, say, 5 years, that consistent monitoring is not happening.
That's also correct. Every year, a client who is on the waiver gets what's called an annual status review, and it ensures that the person is still eligible, which means that they have a condition and they are domiciled in Florida. It also ensures that this level of care component is being met.
So other conditions that might disenroll you from the program are not evaluated at all during that period of time if you're not domiciled in Florida?
No, the agency can't conduct those reviews if you're outside of the state. It has no information about what treatments you are receiving, especially within a very dynamic period of one's life, the childhood and adolescence. And it was that change, not only the passage of time in a critical period of life vis-a-vis these requirements, but also the treatment modalities that were had in Pennsylvania. And Your Honor brings up a great point about 4.0215. I would say this flush left position is opaque at best, but a nuanced reading can provide some transparency. The list of factors and the flush left provision use the word choose only twice. It's in that first element where the client or the client's legal representative chooses to terminate participation in the waiver, and the next time that verb appears is in the second sentence where it provides an alternative, that if waiver eligibility cannot be reestablished, or if the client who has chosen to disenroll has exceeded the time period, then they cannot return to the waiver and they're put back on the waiting list. The rule specifically contemplates that some eligibility determination is going to happen here. It does not. The fourth sentence is actually a mirror of the second sentence, and it's saying that the new effective date is the date eligibility is reestablished. Like
you're skipping over a sentence. It says when this happens, the client is added to the pre-enrollment category of clients. Doesn't say anything about having to be redetermined eligible. And you argue in your brief here that you guys made him submit a new application to establish eligibility, basically because the rule didn't say you couldn't. Well, the rule doesn't say they have to either.
That's correct, Your Honor. However, the statute, the 2021 version of 393.065, subsection 9, it's now subsection 10 in the current version, says that the agency has to remove from the waiting list any individual who is not eligible or is domiciled outside of the state. So even if that were true, the agency would be mandated to remove that person from the waiting list if they can't determine eligibility.
Why isn't the eligibility then related, reestablishing eligibility is kind of based on Judge McIver's question, based on the reason for termination? So if the reason for termination was he left the state, why can't I read this rule to say reestablishing eligibility as he's now back in the state?
That's a great question, Your Honor. That's because that essentially touches on administrative finality. And here, there was that significant change in circumstances. There were new facts, there were changed conditions, and there were additional submissions. There was a litany of evidence that was presented at the fair hearing that didn't exist in 2015. And so, at that point, Section 393.065, subsection 1, buttresses that conclusion, that only clients who are domiciled in the state are eligible. And then when you look at
So at the hearing, then you're saying that the argument was not only left the state, but that his condition got better?
Correct, the presentation did. And 393.065 does not, or I'm sorry, 4.015, Rule 65G 4.015 doesn't make a distinction between types of eligibility. It simply says, in order to be eligible, one must. And then it lists a series of factors that are sine qua non, and without which, then all of eligibility falls apart.
So, reading the rule, it does seem that in this instance, the client is added to the pre-enrollment category, does apply to both waiver eligibility cannot be reestablished, or if the client who is chosen, et cetera, et cetera. Since the rule does seem to indicate that you have to be added to the pre-enrollment category if eligibility cannot be reestablished, what does it mean to be added to the pre-enrollment category without an effective date? I assume you cannot put an effective date down until, in one of those instances, let's set aside moving out of the state, but in one of those instances where you were disenrolled and clearly need to meet re-eligibility requirements, if you never meet re-eligibility requirements and you're put on a pre-enrollment list with no effective date, what does that mean?
I think it means that you're simply, the rule makes you choose. And it's either, depending on the circumstances, you're either going to be determined re-eligible and have that new effective date, or otherwise, you're going to be put on once you request it, depending on the circumstance. So I think...
Well, I assume everyone requests it.
Sure, and that kind of shows how untenable the other interpretation of this rule is. One needs to pick. Either your eligibility is reestablished because, again, we cannot put anybody on the waiting list who is not eligible, or in a circumstance where you've chosen to disenroll, then that new effective date becomes the date that you request. The rules and the statutes do not comprehend being put on the waiting list when you're ineligible. And so what that would mean, if an eligibility determination is not made, then there simply isn't an effective date because you're not being put back on the waiting list. You're simply ineligible.
But if the source of the ineligibility was the relocation, lack of domicile, isn't that cured by moving back to the state?
Yes, Your Honor, it is.
So they have to reestablish eligibility if they've eliminated the cause of the original determination of ineligibility?
In certain circumstances, yes, and this is one of those circumstances where there's been this significant change and where there's been all of this data and information that has happened during the critical developmental period which the rules and statutes focus APD back on. It would be one thing if Rule 65G 4.014 did not say that it didn't have to be pervasive and that it was only a moment in time. Additionally, it would be another thing if it didn't say that it had to be of an extended duration. And so all of that evidence that was newly presented from Pennsylvania touched on both of those factors. Those were significant changes that were material to whether or not there was eligibility. At that time in 2015, I would completely agree with Your Honor and the other side that the only infirmity was moving out of the state. And that's why the flush left provision of 4.0215 contemplates that situation. However, since we're past 365 days and we are unsure of either the pervasiveness or the extended duration, then the agency had to reestablish that eligibility. And the statute and the rule backs it up that there aren't different types of eligibility. It's a binary question whether or not you're eligible. And then once you throw in the specific circumstances of this case, the agency was mandated by the statute to conduct this review.
So, and I'm going to dumb this down a little bit just so that I can follow along. If we were to take appellant's reading of the rule and eligibility was maintained and eligibility never went away, so when you came back and were domiciled again, that was cured, and you were to put the person on the pre-enrollment category, waiver services became available, they started receiving their waiver services within the next year they'd have their reevaluation period, correct?
That's correct.
So your contention then is that at that reevaluation period, if it was discovered they were no longer eligible because their condition had changed, you would have been violating the law for that period of time?
Yes, for that year, and that's why that review is conducted on the front end, because again, 393.065 says that we must remove from the waiting list any individual who fails to meet the eligibility requirements. There's only one way for the agency to figure that out, and that's to do a comprehensive review of the severity of the conditions to make sure that they're meeting these dynamic prongs.
Talk to me about the difference of inquiry, and I realize you only have a little bit of time left, but the difference of inquiry involved in an eligibility determination and in an annual reevaluation. Is one a more depth probing than the other?
Yes, the initial determination of eligibility is comprehensive. It's going to look at all of the factors that are listed in rule, and in this case, 4.014. Additionally, what happens at the annual review level is this level of care determination that, but for the provision of waiver services, an individual would need to be placed into an intermediate care facility for the developmentally disabled. And it is the it is that process that is what is at issue here. And in those annual evaluations, most of the time, there's not that significant change in circumstance because it's happening within a year, not 5, 6, or 7 years.
Not necessarily relevant to this case, but just off the top of your head, how many people are on the Medicaid waiver waiting list currently in Florida?
Around 35,000 people.
Okay.
So to conclude, Your Honors, it was the constellation of factors here that compelled the agency to conduct this eligibility review. It was due to the dynamic nature of the developmental period. It was due to the specific condition that was asserted. It was due to the significant change in circumstances by having nearly 1,500 pages of additional data to review. And lastly, 4.0215 does not necessarily preclude an eligibility determination, nor does it grant individuals who have exceeded 365 days a plenary right to re-request waiver enrollment and be placed on the waiting list. As we have discussed, the agency has to remove those who are not eligible, and it's for those reasons that this court should affirm the final order of the lower tribunal. Thank you.
All right, thank you, Counselor. All right, 4.5 minutes.
Thank you. I'd like to propose a different reading of the word eligibility in the specific code, the 4.0215. In reading that code and that rule, it's about re-enrollment or disenrollment. So when you look at the word eligibility, it can also mean just eligible to re-enroll. Not just requesting a re-enrollment, but is the person eligible to re-enroll? Not are they eligible for services, period. And the agency continues to treat this as a new application. They are talking about the developmental period, the manifestation. That's already been determined. He has a diagnosis of autism. He was on the waiver when he left. He was getting services. He was 5 years old, in 2008 when he first was determined eligible and was put on the waiting list. He was 10 years old in 2013 when he was enrolled in services. He had already been determined autistic then. He was determined to have the diagnosis of autism and the severity and pervasiveness required under the code for the agency. They are now treating this as a new application, making him show it all over again as if he just was diagnosed with this and what his needs are. They have said that the circumstances changed, his condition changed in that 5 years. Well, that would be determined in a level of care assessment just as much, and the level of care assessment would then say if there were changes in his condition, then the level of care assessment is going to say, yes, we can provide these services. We can meet these changes. We can meet the level of care he needs given these changes. Nothing changed, though. He did not have changes. It was testified to that he continued to have the same issues and the same problems. And he has school records from Pennsylvania that have the same issues.
Did the hearing officer disagree with that?
The hearing officer disagreed completely. He did not.
So that was more of a factual finding on his part, correct?
On his part, yes. I mean, we brought up this rule and that this was a re-enrollment, not an eligibility issue, that the burden should shift to the agency and should not have been placed on MN. There was little discussion at the hearing about that, and the hearing officer just said, no, I agree with the agency, burden doesn't shift.
Does your client have any ability to get services other through this process, other than private pay? Is this the only avenue that he has?
No, he would have to go through the Medicaid waiver. And his family is in a crisis situation right now. He and his family, they've been living in an RV. His father and mother have had anxiety issues because of this. His father's was so severe that it created cardiac issues as well. He had to move out of the house for a period of time. This is not, it just happened. This has been an ongoing issue, and he requires these services. So we respectfully request that the decision be reversed and MN be put on the wait list at a minimum, if not provided the services he needs. But he does need a level of care assessment and to be able to give him the services that he needs. Thank you for your time and consideration.
Okay, thank you both very much. Again, a very well-briefed, well-argued case. This time, the court stands in recess.
All rise.